right, here we go. We're good.
Excellent. We are beginning our 4-week adventure into Supreme Court cases today.
Mm-hmm.
So we get to see the specific application of the Constitution, and I guess possibly everything else we've read.
Yeah,
Possibly.
possibly.
But I have a feeling this is going to be pretty. There we go. Yeah, I mean, technical to a degree, as the Supreme Court opinion was a long one. I'm sorry, we're beginning with Marbury versus Madison. I
Mm-hmm.
should announce that. And this is February 1803. Um, and I will just say this: Jefferson won the case.
Mm-hmm.
So Jefferson got his way on this case, and I just thought I'd start with what he said, because we'll find other Supreme Court opinions are of varying lengths. He said that he was happy to win the case, but only noted, in addition to that, that the opinion was longer than it needed to be.
Oh,
So I'm not sure if you found it to be, to have a similar sentiment.
I think it was longer than it needed to be. I feel like it
Yeah,
repeated certain arguments over again.
yeah,
Like it
yeah,
outlines at the beginning kind of the structure of the argument, and then
sure,
which is good, and then it goes
yeah,
into it. But I feel like the whole part about the difference between where was it? Appointment and nominate. Was it appointment
was it
and
original?
nomination? Yeah, and commission.
Oh, okay.
Those things were repeated a lot, and I feel like it was like using those as axioms for other arguments was also
Yeah,
repeated.
yeah. There was some repetition. Yeah, all of those elements are key.
Mm-hmm.
Obviously, the nomination, the commission, the delivery, as it were. I'm sorry, signing the seal.
Mm-hmm.
And then also later, I noticed. I mean, not so repetitive, but sort of important terms since we're on them, were the distinction between sort of appellate and original,
Mm-hmm.
which comes up later in the opinion. So, um, just one thing we probably should get down is the pronunciation of mandamus. So it's
Okay.
mandamus,
Mandamus. Yep.
which is actually a Latin word which means we command,
Mm-hmm.
as the mus ending there, the inflected ending. Um, basically, to sort of begin, I mean, there's a bit of a context, right? Um, and one of the issues in this new early constitutional setting, right? Because the Constitution has been written and ratified at this point,
Mm-hmm.
um, is the defining the federal judiciary. That apparently around this time there was a lot of debate, controversial debates, um, even during the ratification and then thereafter about the federal judiciary's role. So there's sort of like a number of questions that are floating around at this time. Um, the we go back now. It's interesting because as we're doing this recording, we're living in a time where the polarity is between Republicans and Democrats.
Mm-hmm.
But at that time, you have the Federalists and the Anti-Federalists, and the Anti-Federalists feared a very powerful judicial uh, sort of power. There was just there was a problem that if the judiciary had too much power, it could possibly lead to a type of tyranny, which sounds very anti-federalist, right? In other departments, right? They're skeptical of the executive, things like that. Um, and um, it's also interesting to note that five of the 10 amendments that are the so-called Bill of Rights, five of them, so the fourth through the eighth, actually deal with judicial proceedings.
Mm-hmm.
So you can already start to see that there's an issue here about sort of what do we do about the judiciary. Um, and then yeah, so that's you've got this anti-federalist sort of background um, to the judiciary prior to the ratification, during, and thereafter. Um, and then of note, you've got in this particular case of sorry, there we go, Maybury and Madison, is um, you have a lame duck president, okay, which is John Adams. So John Adams is on his way out, and he names William Marbury as this. Apparently, it was a special position. That it was like, I mean, I'm sorry, he names a number of them,
Right.
but it was a special position for the District of Columbia in Washington D.C. Or well, I guess I'm being repetitive in Washington D.C.
Right.
Um, and and so there's, but it's interesting to note John Adams was a Federalist, and the background reading I did is that he was, and we'll have to talk about this at some point. That in general, that he was stacking the judiciary with Federalist leaning judges,
Hmm.
and this sounds a lot like what we hear in the contemporary scene about a Democratic president trying to fill all these vacancies, and not just at the Supreme Court level, but at the circuit and district courts as well, with um, whatever Democratic leaning judges, and vice versa. I think Trump filled, I forget how many in the Supreme Court, three maybe. I want to say four, but that seems huge. But nonetheless, he filled a couple at the Supreme Court, and then also at the lower court. So there's this packing of the court element, which is a topic to discuss, and ultimately maybe how to deal with that, right? Because they have different interpretive approaches to the law. So
Right.
John Adams, you have the Federalist
Hmm.
trying to pack the courts with Federalist judges, and then you have the incoming president, Thomas Jefferson, who is this is interesting in terms of like, hey, you can actually combine these two. A party by the name of the Democratic Republican Party. Wow.
Hmm.
I find this just sort of interesting because, like, it seems like the binaries just never end. But it's interesting that it's a different set of binaries, like,
Yeah.
um, that would have been as impactful as the terms Republican and Democrat for us today,
Hmm.
you know. So Thomas Jefferson is the incoming president. Democratic Republican Party obviously doesn't want the judges from the federal, I shouldn't say obvious, but doesn't want some of the judges that have been selected or nominated by John Adams to fill those roles. So because you have that crossover there, and also you have a changing of the Secretary of State, which obviously becomes very important with the signing of the seals of these commissions. Um, that you could therefore see why the Secretary of State Madison um, would not be inclined to sign. Well, actually, apparently they were signed but not delivered.
Right.
So
They were
signed,
sealed
sealed,
and
but not
signed.
delivered.
Not.
Right.
Yeah.
So that's just a little bit of like the historical context there, which I thought is interesting because part of the reading that I did as well was, it's I think sometimes I might have, and I don't know why, because I tend to be pretty critical, but a little bit of a rose tinted view of the past, these sort of like great rational figures that are
Mm.
working on this new country together, and petty sort of disagreements will be held at a minimum. I'm wrong.
Right.
There's I don't know if it was as acute as ours is now, but it was there, and there was a lot of competing for particular parties to get their candidates in place, whether it be executive, legislative, or judiciary.
Right.
So that gives you. some context. And I actually think it's really funny because when I was reading this, I was like, this is just not a sexy case. Like, they're like, like, the Dred Scott, which we'll read next time, will be,
Hmm. Interesting.
So I was like, where's the sort of, like, in terms of drama, it's
Hmm.
not there. It's sort of boring. But
Yeah.
in terms of digging deeper into it, what the opinion, which was unanimous for the six sitting Supreme Court justices, it was just six at the time, it wasn't nine,
Right.
um, had a massive impact on the role of the judiciary. And that's ultimately, in terms, like, the particulars of the case itself aren't nearly as interesting as the final opinion and then what it meant for the judiciary.
Sure. Yeah, I'm glad you mentioned the affiliations between the different members because I don't think it was mentioned like they were mentioned at
No,
all.
I had to do a little bit of just research on my own, and actually I wasn't even looking for that, but it came up.
Hmm.
I found some of the anti-federalist sentiments first, but it didn't find this other the other piece. But I thought it was interesting, the sort of jockeying for power, jockeying for positions.
Yeah, I mean it gives kind of like I mean that essentially gives the motive behind some of these actions
Yeah,
on both sides of the party, and then this document is very I mean it's a legal document, right? It's a judiciary
yeah,
document. It's very logical in how it's pronounced. So there's
yes,
like it doesn't regard these sentiments.
none,
Um,
none at all.
yeah.
There was just this other. This is just a little tidbit,
Hmm.
but I was like, is this really the case? Um, so let's see. Marshall, I'm not getting his first name right now, but let's just say that doesn't matter. So Marshall is actually the preceding Secretary of State under John Adams. Okay.
Hmm.
And what's interesting, I read this, I was like, you're kidding. This didn't really happen. But apparently what happened, that there was just this, like, really simple, stupid snag that was a step on the way to the larger problem. And
Hmm.
it said, so I'm quoting from an article online. It says the Senate quickly confirmed Marshall to the post. So you got the I think one of it was one of the pieces in the case was getting the consultation from the legislative, right? So,
Yes.
you know, we've got the nomination, we've got from the president Adams, and then we've got the further nomination. Um, I'm sorry, confirmation from the Senate,
Right. The
right? I mean, he
appointment.
should
Yeah.
be in,
Hmm.
yeah. And then it says, somewhat unusually, I'm quoting, Marshall continued serving as Secretary of State after his judicial appointment. Oh, no, that's not the part. That's not the part. Sorry. On March 2nd, 1801, the day before the end of his presidency, Adams nominated Marbury to serve in the newly created post of Justice of Peace in the District of Columbia. Oh, I'm sorry. What I had read was about Marshall. Marshall was actually nominated and confirmed. Sorry,
Okay.
as Secretary of State. So we got the Secretary of State done. So anyway, Adams nominated Marbury, as we know, to serve in the newly created post of Justice of the Peace in the District of Columbia. The Senate approved Marbury's nomination the next day. Adams promptly signed Marbury's commission, and Marshall affixed an official seal to the document. Now, this is the funny part. Marshall's brother, James, was supposed to deliver the commissions to the judges, but returned several, including Marbury's, when he found he could not carry them all.
Huh.
Marbury had not received his commission when Marshall left office shortly after James. It's like getting lost. Like we just did a what is it called? An amended tax return
Hmm.
for 2018. Blah blah blah. And literally, it got lost in the mail. We didn't certify it, so they didn't get it at all. It's something we did a year ago.
Oh, weird.
This is a similar case,
Yeah.
almost.
I wonder how
This
many he
is,
couldn't
but
carry.
but how big are they? Like, I mean, I do think he said they were 42.
Mm.
So, you know, just a small little bit, but funny at that,
Yeah.
if that is accurate. So what do you make of the case? How do you want to jump in to maybe like the particulars, etc.?
Mm-hmm. I mean, it's a good question. So
There's
it's
just so much,
there's a
right?
lot. It breaks it into three kind of operations that
Yeah,
we've already mentioned: the nomination by the president, the appointment, which requires the consent of the Senate, and then finally the commission. So those are kind of the 3 points of argumentation
yeah.
about um, the results. So we can probably
The
touch.
first two,
Yeah.
um, the first two, Marshall basically says, well, wait, the first one is like, yeah, does he have a right to the commission? Yes, that's a no-brainer, given the rule of given the rule of the executive nomination. I believe consultation. I'm not sure if he was confirmed by the Senate, but I feel like there was a talk about um, the president receiving consult from the Senate. Um, and then, so basically, it's yes to that, right? He does have a right to the commission. Two, the question is, was a writ of mandamus the proper remedy? Um, which I, I guess the sort of thing that's confusing about that is, what are your other options? Like, in other words, was a writ of mandamus the proper remedy? I guess another thing would be like, oh, I guess this is already um, like to the fact, right? In other words, because Marbury is appealing for a writ of mandamus.
Right.
My brain's sort of thinking, well, aren't there other types of remedies? But let's just say, since he is asking for that, right? Um, is that proper? And I believe he's saying yes to that, right?
Um.
Not yes to the third one. That is, does the Supreme Court have the right to issue such a mandamus? But was a writ of mandamus the proper remedy?
Right. Yeah. I think he was right. If he was right that a right had been violated, the laws of his country afford him a remedy. Okay.
Right.
So the second was do they afford him a remedy, and that was yes.
Yeah,
Um.
because essentially I mean, another way of saying that that's a little bit more straightforward is, um, can you does he have the right to properly sue in court
Yeah.
for this issue, about this issue? And
Yep.
and I would say yes, he has the right. A right's been violated,
Mhm.
and one remedy for a violated right is to seek a lawsuit. So,
Yep. And
and
all
and
of
have
your
and have a court hear it.
and all of your legal rights are protected by the laws of the country. So
Correct.
they
Correct.
require a remedy of sorts.
So it's
Um.
the last one that's the real sticking point, right?
Yeah. Let's see.
Because I feel like with the first one, it's just straightforward. In other words, the executive, from the Constitution, the executive has the right to nominate.
Mhm.
There is a process by which that nomination is done. That's the whole sort of technicality, or what he calls ceremonies
Mhm.
of I think he calls it ceremonies, maybe something else, um, of the signing and the sealing, right? Um, but then it's this last question that is the problematic one, and that is whether or not the Supreme Court has the right or the role to issue that mandamus.
Right. And then what? This is on page 7 of the document we're reading from.
Right.
So this said, it remains to be inquired whether, thirdly, he is entitled to the remedy for which he applies. This depends on, first, the nature of the writ applied for, and secondly, the power of the court. And this is where the issues of this third point come in.
Yeah, yeah.
And we get a
So
definition of
it's two.
mandamus.
Yeah, it's two. Go for it.
So here, this is Blackstone in the third volume of his
Mhm.
commentaries, page 110, defines a mandamus to be a command issuing in the king's name from the court of the king's bench and directed to any person, corporation, or inferior court of judicature within the king's dominions, requiring them to do some particular thing therein specified,
Right.
which appertains to their office and duty, and which the Court of the King's Bench has previously determined, or at least supposes, to be consonant to right and justice.
Right. So the mandamus. So I imagine one could do a genealogy or history of the mandamus. That this has been around
Sure.
for a while. This has been in the legal system of common law within the British Empire, right?
Mm-hmm.
So that I'm sorry, that was the remedy.
That
The
he's
reason that
requesting,
they're
right?
right,
Yeah.
right, but also the reason he's requesting it most likely is because this is what has been done in the past,
Mm-hmm.
right? Um, and what is interesting is that you're doing this within an entirely new system. You're not with the legal system in Great Britain at the time. That's a long-standing, centuries-old system, right? So hey, your right has been violated. You seek out the mandamus.
And to be
So most likely
clear,
that's why. Yeah.
what he's requesting is the command issuing the president, right,
Yes. Correct.
to allow him that position.
Correct.
Yes. Okay.
Absolutely. And therefore, the Supreme Court sort of having that power, right,
Or yeah.
to the Supreme Court having that power, right? In other words, he can't appeal to the executive because the executive doesn't even want him to have the position.
Yeah.
There is a question of why he couldn't appeal to the legislative, but nonetheless, I guess most likely when you're like, yeah, well, I
I don't
guess
think you could appeal to the
you can't
yeah.
appeal to the legislative because the legislative's function is to create laws.
Yeah.
And not to resolve disputes.
Yeah.
So because you have a dispute, you go to the Supreme Court.
Yep.
The problem is that the way they answer it is obviously not in Marbury's favor. So and I understand. So in other words, it's not in Marbury's favor, and yet Marbury himself has done nothing wrong.
Right.
So it seems like even with all of the other beautiful things that come from this case, that we'll discuss later about the role of the Supreme Court, I feel for Marbury not getting
A
what he
remedy.
deserves.
Yeah.
Yeah, yeah, you
Yeah,
know,
it almost seems like someone should offer him a
like
counter remedy.
exactly. I mean, in other words, there's no higher court of appeals at this point
Mm-hmm.
once the Supreme Court has made their decision. Now, I understand that the Supreme Court's not always, whatever. If someone feels that they've been had a right violated, they're not always going to be side with that individual. But what's interesting about this case is that everything was, as it were, constitutional and according to due process
Mm-hmm.
for this position. You know,
Right.
so it seems like he's without any recourse after this has been announced. In other
Mm-hmm.
words, he just has to sort of suck it up. You know.
True. Let's see, I'm trying to find the part where they address the power of the court. Because that was the real issue, right?
Yeah.
Um, is this on page 10?
I feel like it's gonna be later. Yeah, in the document.
Let's see, there's some things highlighted there. Yeah, I think, okay, on page 10 on the left column, you have
Yeah.
a paragraph highlighted. Um,
Yeah, I see.
that's the conclusion, which is
Yeah.
that by the Constitution, the Supreme Court does not appear to have the power of mandamus.
Right.
Now, I think part of the issue was that there were two conflicting uh, pieces of law. Is that right?
Right.
Because I think,
That you are absolutely right.
yeah.
So what happened is that the very first law that was passed, by the way, it's an interesting sort of historical piece.
Mm-hmm.
The very first law that was passed in the first Congress within the new Constitution was the Judiciary Act of 1789.
Mm-hmm.
It, by the way, it does a lot of things because the Constitution leaves open exactly what the judiciary from the federal all the way down through state and local should look like.
Mm-hmm.
So what the federal, what the Judiciary Act of 1789 does is actually spell that out.
Okay.
Um, a lot of it was sort of straightforward, but essentially it was setting up circuit and district courts within states. And
Mm-hmm.
so when you read the document, I was going to send it to you, but a lot of it's just it's very boring legalese. A lot of it is, not all of it,
Sure.
but a lot of it is literally sort of like setting up like, hey, and this particular whatever, and Massachusetts will have this particular court, and so on and so forth.
Mm-hmm.
And I think certain courts were like certain states where they had them combined, the circuit and the district. Anyway, so that, and apparently that's an important act because the way in which the courts are structured for us now all depend upon that act. So what the tension then is this, that it's section 13 of that Judiciary Act that states this: the act to establish the judicial courts of the United States authorizes the Supreme Court to issue writs rather of mandamus in cases warranted by the principles and usages of law to any courts appointed or persons holding office under the authority of the United States. So what's happening here is that, and this is the real nut of the case,
Mm-hmm.
is that Marshall is basically arguing that this section, not the entire Judiciary Act, but Section 13 is unconstitutional.
Okay.
That it
Yeah.
basically exceeds the original jurisdiction given to the courts in the Constitution. Um, and that basically this is where it becomes interesting, is that the that the two things happen here. One, it's the court arguing. I'm sorry, you've got the particulars of the case, Marbury, etc., in his claim,
Mm-hmm.
but he's utilizing, I mean, and seemingly fairly so, a Judiciary Act that had been established by Congress.
Mm-hmm.
Supreme Court then, under Justice Marshall, it argues that, sorry, the guy who wrote this opinion, argues that that particular piece is unconstitutional. It gives, in other words, it's way outside the jurisdiction of the Supreme Court to issue these particular writs.
Right. And the section 13, that part that you just read, was that
Yeah.
a generalization of courts and like of courts, or was it specifically for the Supreme Court? That power of
So the
mandamus or
act, let's see,
writs.
the act to establish the judicial courts of the United States, Supreme Court,
Okay.
authorizes the Supreme Court to issue writs of mandamus, et cetera, et cetera, et
Mm-hmm.
cetera. So, so you've got two things trumping Congress here. One, you've got the Constitution trumping them, and
Yep.
two, you've got the Supreme Court trumping them as well. I mean, maybe you wouldn't say the Supreme Court, but at least Supreme Court is holding Congress accountable to their to a law or a piece of law that the court sees as unconstitutional.
Right. And this is interesting because that
Very,
act was back from 1789, so that was what, 12 years prior?
yeah, yeah, yep, yep, yep.
So they are judging
Oh, less than that, less than that. This is 1803.
no, 89,
Oh,
not 99.
89,
Yeah. Oh, so
89. Gosh,
14. Yeah, 14
you're
years.
right. Yeah, yeah, yeah.
Um yeah, so I mean, they are judging a prior law an act, right, as
Yeah,
unconstitutional. And what's funny
right.
is that that law is governing how they are to act. So
Correct.
it's like this. It's almost like a feedback loop.
Yes.
It's they're solving an issue about their own structure, which is a good thing,
Yes.
but it's just an interesting
Precisely.
thing to wrap your mind around.
Yeah. No, exactly. I mean, this is where, if you read more about this beyond the context of our case, but this is where the whole notion of judicial review comes up, where
Hmm.
the Supreme Court can cannot just hear cases, but in so hearing them, um, because I don't think that I don't think that the Supreme Court has the ability to say, okay, let's look at whatever we want. I think a case needs to come up,
Right.
right? A case needs to come up, and then I mean, I think they were trying to do this with, or there were attempts to do this with the Obamacare, right?
Hmm.
His sort of universal health care bit. But a claim needs to come up, but
Right.
obviously, whatever decision is made is 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 allegedly constitutional,
Right.
right?
Yeah, because like if
Um,
you were to incorporate the judicial branch into the legal process, then you're just basically adding another. Like we already have checks and balances within the legislative branch with the
right,
Senate and the House. So it would just be adding a
right.
third party in there. So it makes
Hmm.
sense that you let the legislative branch operate, and then if problems arise from it, then it comes to the judicial branch to resolve those problems.
Exactly,
It is
exactly. But
especially weird that those problems were regarding the operation of the judicial branch.
yeah, exactly, exactly. And so it's the I mean, I think what's brilliant about it is at first, as I was reading it, so I did not remember it from so many years ago. As I was reading, I was like, "Oh, Marbury's got this. Like Marbury's
I know,
got this.
right?
Like it's in the bag. And then I was like, oh, like it's not within their, it's not within the Supreme Court's jurisdiction according to these justices. And actually, you know what? I will say this: I do appreciate, other than the fact that he's proposed, I do appreciate it's sort of like, you know what, Marbury, you get partial credit. I'm gonna give you the fact that it is your right to have this commission. I'm going to give you the fact that you have the right to sue or
Hmm.
seek out
Hmm.
this writ, but we can't do it.
Yeah.
We're not the ones that can ultimately issue that.
Yeah.
But what's interesting, what does interest me though, is that, and maybe this could just be a legal technicality, like in terms of legal uh, jargon,
Hmm.
and therefore the jargon matters, and you start to make separations and distinctions. But it's sort of like, and not just my earlier issue, but that earlier issue does matter. It's like, well, what recourse does he have? Everything was legitimate, seemingly. Um, but I guess, and I'm curious if this would be the case, but I guess like a new precedent would be set. That is to say, if you were in this situation again during a lame duck presidency, where they're making appointments, but it's not fully like completed,
Hmm.
then, and I don't know if that's the case. If there are other little laws here that have done checks and balances, I don't know. But that yeah, you don't need to honor them. Even you don't need to honor those nominations, so on and so forth, because um, whatever, we have this new precedent set by Marbury Madison. That's one element.
Right.
Um, the other thing, though, is that I mean, obviously, when with other Supreme Court cases, someone it is making a claim of a violation of right. One and two, pursuing it's a lawsuit
Hmm.
of some sort, right? So how, and this might be the technicality, how is this different? I guess I don't know. I mean, how is this different from, in other words, like, I mean, let's say that you have a particular case, it goes up to the Supreme Court, it's not this issue, and then the Supreme Court decides in your favor. Well, someone or some institutions in the United States need to conform to that.
Hmm.
So I'm not really sure how this is that different. Uh, you know what I'm saying? Like,
I'm trying to understand.
um, well, my point is, if if the Supreme Court decides in your favor or even against it.
Well, in
Okay,
this case, they're deciding against the favor, and they're modifying something about the law, right?
correct. But I guess what I'm saying is that when the Supreme Court does, let's just say, because maybe it's a little bit easier, if they decide on your side, that means that persons or institutions need to conform to that,
Mm-hmm.
and and therefore, whatever the violated right needs to be made right, or needs to be corrected.
Right.
Um, so I'm not really sure why this isn't the case. Like, I mean, in other words, well, I'm sorry. I guess what the difference is that there. I guess I'm going to try to be clear. Is it the writ of mandamus would basically, if they approved it, they would basically be forcing the sitting president to accept Marbury as a judge.
Right.
So, is is it down to the technicality of a writ of mandamus, or could it have been another approach to the Supreme Court for him to secure his position?
Mm.
Do you know what I'm saying? Because what happens in a Supreme Court case is that when they do make a decision, someone is affected by it, and someone might need to conform to it. Let's say the other party. They're gonna, and I see the president as being sort of the other party in this case.
Yeah, definitely.
You know, so my point is it specifically about the writ of mandamus, or had he tried another approach and it wasn't a writ of mandamus, but it was like I don't know, like um, you know what? Here, I'll give you an example. I feel that I need some type of reparation and I should get a year's worth salary, something like that. I don't get the position, fine, but some type of
Mm.
like would it have played out differently?
Sure.
I guess my point is it all riding on the technicality of this particular kind of writ, or could there have been other avenues to get something, either the position or some other type of reparation?
Right. No, that's a good point. I think um, if since this is the route that he went for in like an appeal,
Yeah.
for a remedy, then it's definitely regarding that mandamus, and
Hmm.
the party that is involved with that is the president, and the judicial branch determined, or the Supreme Court determined, that they do not have power over that
Yeah.
aspect.
Hmm.
In which case it falls flat. So,
Right.
but
Right.
if that's the only way he tried or could try for a remedy, that, yeah, I guess that remains unknown. I don't know if you looked at all to see if he did
I
anything
mean, I don't know
after
what
the results of it.
I. I mean, I guess here's the point: is that the writ, if it does connect to the the etymology of sort of like a command, like in
Mm-hmm.
other words, the Supreme Court commanding, right, that he be um, given the position. Um, you know, if there's some sort of like piece there that plays into it, like the Supreme Court giving a command. But see, I don't know. Like I would imagine when it comes to judicial review, and we'll find this out in other cases, but the Supreme Court is going to stick it to the legislative or the executive on being unconstitutional. I mean, in
Mm-hmm.
other words, they're allowed to make a decision, and that's my point about the writ that sort of throws me off. You know,
Right. Yeah,
in
like,
other words, the decision affects, and maybe we could just put it really general. It will affect or can affect the executive. It can affect the legislative.
mm-hmm.
In this case, it certainly would have affected the executive because the executive would have had to submit, if, to the ruling of the Supreme Court, and Marbury would have got his position.
Mm-hmm.
So when I go back to that notion, certainly the Supreme Court can do things that will affect either branch or hold either branch accountable.
Right.
Um, and is it just that this form, because they disagree with the specific wording in the Judiciary Act, up against the Constitution, that dismisses the finally, well, not dismisses the case, but decides the case?
Yeah, I mean that sounds right. Like it,
Um,
because
and, Yeah.
they were going off of the Judiciary Act as the point of contention. Like
Yeah.
that's the source of that power, right?
Right.
And then I don't know what prompted them to look at back at the Constitution to verify it,
Yeah.
but they did, and they found that it doesn't grant that power, and it has precedent over it, right?
Right.
And then they made I guess they made the. Well, I don't know how that works. Do they decide that it has precedent because of history or because of
Which the
timely?
Judiciary Act?
Uh, do they did they determine that the Constitution has precedence over the Judiciary Act because of historical time? Like, it came
No,
first?
because I think, be, I wonder whether or not these things were being determined,
Mm-hmm.
right? But there's one line I had put this to my notes, so I don't have the page number.
Mm-hmm.
But Marshall says at one point, if the Constitution is superior to any ordinary act of the legislature, the Constitution, and not such ordinary act, must govern the case to which they both apply.
Okay. Mm-hmm.
A law, another one is a law repugnant to the Constitution is void, and courts as well as other departments are bound by that instrument.
Mm.
So the 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 and I think we were um, I think we discussed this when we were dealing with the Constitution, and I imagine the bill or the amendments, the Bill of Rights and the amendments, is that it is bedrock, right?
Mm-hmm.
It's the foundation, and then when you're coming up with new legislation, you have to compare it to the Constitution.
Yeah. Yeah.
And then without that check, without the check, even Justice Marshall brings it up in this case, the fact that it is written, right? He repeats that a couple of times. Means that you've got this to compare to. I mean, and if you don't have the Constitution, this becomes interesting. Or you don't have like these guiding principles,
Mm-hmm.
right? Then then really, I mean, you could legislate anything, right?
Yeah. Yeah.
And then that, I mean, well, for some maybe that wouldn't be a problem, but for others that would be problematic. Whatever. One day, whatever. You get back to sort of like a Thrasymachus thing, where it's all up to the tyrant. So what is moral one day becomes immoral or illegal one day becomes illegal under a different tyrant.
Right.
The law can just shift all around. I mean, probably something like the importance of civil rights in the United States is heavily connected to things like life, liberty, and the pursuit of happiness. Many of the amendments, sort of structurally, right?
Right.
Where it's sort of like it's probably not going to ever happen in the United States unless it's overthrown, where you'll have legislation that will be anti-civil rights.
Mm-hmm.
And part of that is due to the fact that you've got this built in to your bedrock constitution.
Yeah.
I do think what's really interesting too is that a couple things actually um, that the the first one is that this is actually a Marshall quote. He says it is emphatically the province and duty of the judicial department to say what the law is.
Right.
Now, I think that's really interesting because you know um, maybe a fuller quote, and again, I don't have the fuller quote, but I do have that part. Is is that the Constitution,
To say what
or
the
is
law is?
that the yeah, is that the Constitution, law as Constitution, or is that also law as all the laws that come out of the legislative branch. It seems sort of odd to say that it would be the laws that come out of the legislative branch, because then you have to get back to questions like, well, you have to get back to interpretive questions, right? At least with the Constitution, you've got a set text written by individuals, all dead now, and that has been around for a long time, and that has been interpreted by previous Supreme Court justices,
Mm-hmm.
right? So to say what the law is makes sense at the constitutional level. Doesn't make so much sense to me at the legislative level, because it's constantly new movers and shakers and players in that area. You can't get back to the author's intention, right, for every different law.
Right. I feel like
Um,
it makes sense though. Um, but are we talking specifically about the Supreme Court determining the law?
Correct.
Right. So,
Correct.
I mean, like you said, it does make sense that they would determine the law from the Constitution, um,
Yeah.
and the amendments that follow it. But I think it's almost like it's required for them to at least address the legislative
Yeah.
laws, because
Agreed.
otherwise they can't have any sort of backing to, what's in
Right.
place.
And I do think that when it comes to, we dealt with this when we were looking at the Constitution, and I opened up with a number of theories of interpretation
Hmm.
of the Constitution, and one of them actually did one broad area was precedent. And
Yeah.
I don't think that that was just judicial precedent. Like, that makes sense. How did this justice decide on this case, so on and so forth? Like, that makes total sense. Um, and but I believe as well, wrapped up in that was also looking at other laws that had been passed.
Hmm.
Um, but you get my point. Like, it's one thing to say, I'm going to tell you what, our role is to tell you what the law says, and means. If it's at the level of the Constitution, I'm fine with that. I mean, to a degree, there are other interpretive snags, but in general, that's fine. It's a relatively short document. As I said, the framers of that document, are all living at a particular time. You can look at the history. It's easy, I should say,
Hmm.
than interpreting all laws, as it were, that have come out of the legislative branch,
Hmm.
because you have, I'm not even sure how you go about that. Meaning, in other words, like, if you play into the author's intent, that's really tricky, because you have so many different senators proposing bills, and writing them. Sometimes you have a few of them that really write the bill, and then others vote for them.
Hmm.
Um, so I feel like that gets a little tricky, but clearly, this case shows that the Supreme Court does tell us what the law says, because it declared this particular act of Congress invalid.
Yeah. Yeah.
You know,
Um, I mean, when you first posed that quote, I think the way that I interpreted it was that Congress's job is to declare what the law is, like as it supports the case, right?
right?
And I think that clearly requires both constitution and legislative works, because those are what govern the people and those are what govern the country's actions.
Yeah,
Um, when you started bringing in to account the intents, then it definitely does get hairier. Like,
yeah,
you can understand the intents behind the Constitution fairly easily, like you said, because there's so much time behind it, because there's so much
yeah,
backing behind it, and the people are who originally created it are not part of the picture right now,
right.
and the evidence of it continues to permeate our lives.
Sure,
But when you consider the legislature, like, are you going to consider legislature that's been around longer differently than you consider
sure.
more recent legislature?
Yeah, yeah,
Um,
exactly. I mean,
yeah.
let's just say the healthcare law that was passed under Obama. is the Supreme Court going to tell me what it means?
Well, they're going
I
to tell
mean,
you what
that
it
just has a
says.
specific.
Yeah.
Yeah, it
Are they
does
going to tell
though.
you?
Yeah.
Are they going to tell you what it
Okay.
means? I mean,
Right.
I'd imagine they'd have to tell you what it means because in order to judge
Yeah.
something, you have to know what it means.
Yeah.
Are they going to tell you if
Here's
it is law?
yeah.
That also seems like what they're doing in this particular case. So,
Yeah.
if
Well,
it comes to the
the,
Supreme Court at a certain
yeah.
point in time, I think
Yeah.
then there's clearly an issue with it, and then it clearly needs to be judged.
Well, here's the issue. I and I don't know why I had this brain fart. They are telling us what the law means
Yeah.
because in this particular case they're appealing to a judiciary act which came from Congress,
Hmm.
right? So they are in this case certainly telling us what it means or what it
Yeah.
says, right? Not just the Constitution,
Yep.
right? And I imagine, and it'll be interesting to see whether or not in other cases, other legislation, not just Supreme Court decisions, will be appealed to,
Hmm.
and in that, they will be telling us what it means.
Yeah.
Because essentially in order for Marshall to say, um, I can't issue this writ. I understand you can appeal to the Judiciary Act, but I am actually saying that that piece of the Judiciary Act, so my reading of that legislation that came from Congress, is unconstitutional. That is a type of reading of legislation and telling us what it means.
Right.
So it is sort of interesting. I mean, that I would say that this really does open up the power of the Supreme Court uh, pretty vastly. I understand it's different. They can't create a law, right?
And they can
As it
only
were.
judge laws that come up to them.
Yes, exactly. But to be able to look at a piece of legislation and say that it's unconstitutional, that's powerful.
It
It's
is,
not
but
just
it's
it's not
also it's like the legislative branch made a logical fallacy in their laws.
yeah
And someone's
yeah
got to find that, right? And they ended up
yeah
finding it here. So it's it like logically doesn't work as a law. So it makes sense that like something's got to remove it. Um,
totally
Otherwise, you'd have issues with the legislative branch creating laws that could potentially contradict one another.
Correct. But I don't think that historically this piece was thought of until this decision.
Hmm.
Um, and that's what I'm saying. It's sort of like I want to say that there were a lot of question marks about the function of the Supreme Court, other than hearing cases. I mean that like in its most sort of like simplest and stripped down sense, that's what the Supreme Court was to do. This is a little bit more subtle, and in its subtlety, speaks to the extent of the Supreme Court's power to interpret. Let's say,
Hmm.
you know, certainly not the power to issue writs of mandamus, but
Right.
their power to interpret. Um, the one thing I did want to close with, in the spirit of watching our time today,
Hmm.
is um, so this notion of judicial. They call it judicial review now. This notion of the Supreme Court's role in actually stating whether or not a piece of legislation is constitutional or not. But what is really interesting is that it's not specifically granted in the U.S. Constitution,
Hmm.
and I think that's very interesting, as it relates to. I'm not saying it has to be, but I think it's very interesting as it relates to one's interpretation of the Constitution, in terms of like I think one can say too literalist of a form of interpretation would not allow for judicial review, right? Because it's not there. I'm
Hmm.
sorry. It reminds me of this. It's sorry. It just popped in my head, but you can appreciate this as a good Protestant. But I remember John Calvin's hermeneutic when it came to the Bible was that basically you can only do what is prescribed,
Hmm.
and Martin Luther's was somewhat different. He was like, um, you can do anything that is not specifically um, commanded against.
Hmm.
So, and I think this was on the like issue of Christmas celebration, because John Calvin was more of a Puritan and was like, no, it's not mentioned, therefore, it's not right to celebrate Christmas. Martin Luther was like, hey, it's not in there, but it's not it's not commanded against.
Right.
So it's sort of like the like too literal of an interpretation of the Constitution would not allow for judicial review because it's not there. It's not prescribed. And it's sort of interesting to think like about a document that has sort of that it certainly allows it though, right?
Right.
So it's interesting to think about a document that is structured or I'm sorry, is structured in such a way and or one orients oneself to that may have elements in it that arise that possibly the framers didn't even anticipate.
Right. Yeah. And I
Do you know
mean,
what I'm saying?
if we
Sort of like,
go,
like something like, yeah,
was it Hobbes' Leviathan that addressed this? Like it kind of sounds like the was it precedence? Is that what it was?
yeah, yeah, a prerogative,
Prerogative, where
yeah,
there is something isn't specified,
yeah,
and you need to take that action to
yeah.
fill the gap. But
But
it's
what's interesting is that judicial review,
mm-hmm,
not originally stated in the Constitution, prior to Marbury Madison, probably like wasn't really thought up,
mm-hmm,
even as an idea, but it is constitutional, you know,
sure,
meaning in other words, even though it's not explicitly stated, it's constitutional, which means that it's allowed for somehow within the context of this text. And,
right,
and I find that just a very interesting idea.
yeah, it is
Something that
interesting,
is not explicitly stated is nonetheless there. Or if not there, allowed.
right,
Which, by the way, sounds maybe a little bit more like the Martin Luther hermeneutic than the
yeah,
John Calvin.
yep,
If it's not explicitly prescribed against, you can allow for it.
yeah, and I think that's kind of how laws generally are,
Yeah,
right?
yeah, yeah.
Because then it allows
But I,
freedom.
but I think what I would say is it then defeats a strictly literalist interpretation.
Sure. Well,
Because
maybe. I mean, does it say that these are the full extents of the judicial power? Like, is that how it's iterated in the
no,
Constitution?
no,
So then
no,
that wouldn't be literal. If
yeah.
all of the powers of an entity are not fully extended, like fully listed, then you
Hmm.
have to assume that there's something that is not explicitly written that is an implicit power, right?
Hmm.
So I
Hmm.
don't even
Hmm.
know if you say that that's the literalist approach. Like that's saying
No, you're right. You know what? That's fair, Christian. I think that if the framers were smart, they would have written the document for the future as
hmm
well as the present,
yeah.
and leaving certain things like open to future generations.
hmm
I think probably, um, if that was the intention, there was a wisdom in it.
Yeah.
Like for instance, these lower courts that the Judiciary Act, um, with this mandamus writ, but the lower courts that were established in the Judiciary Act, they're not found explicitly in the Constitution, right?
hmm
So and I'd have to look at it. I don't know if it's Article 3 of the Constitution, but it's something where they talk about the Supreme Court, and if they mention like other courts, well, okay, you know, it's open
hmm
how future legislators are going to determine what those other courts are going to look like, or lower court, So
Right.
that's fair. In other words, the like it's still connected to the text, even if it isn't, explicitly stating, um, the details of what it should look like,
Right. So I think
right?
what you were describing wasn't necessarily like literalist as in what the text says. It's extent
Yeah,
it's taking another lens on it, right?
yeah,
Like you mentioned, the
yeah.
Calvin versus was it Luther? Is that what you
Martin
said?
Luther.
Martin Luther.
Hmm.
Yeah. That's taking a different lens over the text. It's not
Yeah.
necessarily literal. Like that's saying how to deal with the gaps, right?
Yeah. Yeah.
That's not saying that there are not gaps.
Correct.
Yeah.
Correct. And I think too, like, the life, liberty, and happiness,
Mm-hmm.
right? I mean, there's strong terms that direct a lot of like our thinking as Americans, but at the same point, like there are a lot of different ways to sort of apply law to them, you know,
Mm-hmm.
um, but also, restrict certain behavior as well that will, you know, challenge one's life or one's liberty.
Mm-hmm.
You know, there's room to play with in terms of how to, um, implement new laws, etc., that will sort of reflect their character, even if it's not spelled out.
Mm-hmm.
So that's fair. But it is interesting, sort of this like, whoa, what is this judicial review thing?
Yeah,
Comes up
definitely.
now, and it's like, okay, now a precedent is set,
Mm-hmm.
uh, and 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 I guess because there was sort of an open definition about the court in the Constitution, yeah, there will be a Supreme Court fine, but what will its functions be? What is the like in its day to day and in its specifics? That's going to ultimately need to be hashed out, but still can go back to the idea that hey, it needs to be a separate branch, other constitutional features, other things you find in the Constitution.
Right. Yeah.
Good.
Cool.
Stop there.
All right. I will stop the recording.